My name is Jennifer Kuyrkendall Griffin. I'm running for Suwannee County Judge. In this installment of Scales, or Suwannee County Access to Legal Education series, I am discussing mandatory disclosure in a domestic relations case. Mandatory disclosure has to be completed in all domestic relations cases, except proceedings involving adoption, simplified dissolution of marriages, enforcement, contempt, injunctions for domestic, repeat, or dating violence, and uncontested dissolutions when the respondent is served by publication and does not file an answer. Mandatory disclosure is governed by Rule 12.285. Now, this rule distinguishes between what is required for temporary relief and what is required for initial or supplemental proceedings. An example of temporary relief is temporary alimony or temporary child support while the dissolution of marriage is pending. The rule identifies 16 different areas that have to be disclosed. And quite frankly, most people don't have all of the different types of mandatory disclosure. So I'm only going to address the most common areas. Probably the item everyone is most familiar with is the financial affidavit. The financial affidavit will identify your income, your expenditures, your assets, and your liabilities. You will also be required to provide all federal and state income tax returns for the past 3 years. You will be required to provide your IRS forms, the W-2, 1099, and K-1. You will need to provide pay stubs or other evidence of earned income for the 3 months prior to service of the financial affidavit. You will also need to provide all deeds within the last 3 years. You will also need to provide all periodic statements for the last 3 months for all checking accounts, and the last 12 months for all other accounts. Now, there are many other categories of things subject to mandatory disclosure, but today's installment only addressed the most common areas. Now, one more thing I do want to touch on is the timing of when all of this is due. Any document required under Rule 12.285 for any initial or supplemental proceeding shall, that's the strongest word, be served on the other party for inspection and copying within 45 days of service of the initial pleading on the respondent. There's a lot to gather and to disclose. So if you are planning on filing for divorce, it is a good idea to gather all of your disclosures prior to filing because 45 days is going to fly by before you know it. Now, today has been a broad overview about mandatory disclosure. If you found this information useful or you know someone that could benefit from it, please like and share and follow the campaign's social media. If you'd like to help the campaign, please invite your friends to follow the campaign's social media as well. If you have a particular topic you'd like me to address, send a message through the campaign's social media or website, and I'd be happy to film a video on the topic. Just remember that I can't talk about a specific case or facts, but I can speak in an educational manner. If you ever miss an installment of Scales, visit the campaign website to see all of the Scales videos that are available. And remember, on August 23rd of 2022, I'm asking you to vote for me, Jennifer Kuyrkendall Griffin, for Suwannee County Judge.